Please get ready for exercise 85 from Dr. G.D. Bist's Legal Dictation. 5 seconds. Start. On that analogy, an administrative decision is revocable while a judicial decision is not revocable except in special circumstances. Exercise of power of a subordinate legislation will be prospective and cannot be retrospective unless the statute authorizes such an exercise expressly or by necessary implication. The principle laid down in section 21 is of general application. The power to rescind mentioned in section 21 is without limitations or conditions. It is not a power so limited as to be exercised only once. The power can be exercised from time to time, having regard to the exigency of time. When by a central act power is given to the state government to give some relief by way of concession and or rebate to newly established industrial units by a notification, the same can be curtailed and or withdrawn by issuing another notification under the same provision, and such exercise of power cannot be faulted on the ground of promissory estoppel. The purpose of the General Clauses Act is to replace in one single statute different provisions as regards interpretations of words and legal principles which would otherwise have to be specified separately in many different acts and regulations. Whatever the General Clauses Act says, whether as regards the meaning of words or as regards legal principles, has to be read into every statute to which it applies. Further, power to curtail and or withdraw the notification issued under section 49 of the Electricity Supply Act 1948 giving rebate is implied under section 49 itself on proper interpretation of section 21 of the General Clauses Act. Therefore, power to curtail and or withdraw the notification issued under section 49 of the Electricity Supply Act 1948 granting certain benefits was available to the respondents by virtue of section 41 and 21 of the General Clauses Act. When a power is conferred on an authority to do a particular act, such power can be exercised from time to time and carry with it power to withdraw, modify, amend or cancel the notifications earlier issued to be exercised in the like manner and subject to like conditions, if any, attached with the exercise of the power. It would be too narrow a view to accept that chargeability, once fixed, cannot be altered. Since the charging provision in the Electricity Supply Act 1948 is subject to the state government's power to issue notification under Section 49 of the Act granting rebate, the state government, in view of Section 21 of the General Clauses Act, can always withdraw, rescind, add to, or modify an exemption notification. No industry can claim as of right that the government should exercise its power under Section 49 and offer rebate, and it is for the government to decide whether the conditions are such that rebate should be granted or not. There being nothing repugnant to raising of public revenue in exercise of sovereign power of state to impose and collect taxes, including electricity duty, in any provision of the Act of 1948 or the policy statement made in the notification granting rebate, the raising of public revenue by withdrawing or reducing exemption cannot be said to be against the provisions of any statute. Noticeably, the new industrial units which were being established in the hill areas could not have compelled the government to exercise power under Section 49 of the Act of 1948 in their favor for grant of rebate concession in electricity tariff. Powers under Section 49 normally would be exercised by the state government for industrial growth of an area and to generate employment opportunities for those who are residing in that area. However, on change in the circumstances, the government can always reconsider the matter and can either curtail or withdraw the benefit granted earlier. The concept of larger public interest introduced before invocation of Section 21 of the General Clauses Act in fact amounts to amendment of the said provision, as notifications dated June 18, 1998 and January 25, 1999 issued under Section 49 of the Act of 1948, as well as notification dated August 7, 2000 issued under Section 24 of the Uttar Pradesh Electricity Reforms Act 1999 are in the nature of legislations, and therefore the principle of promissory estoppel would not apply to them. That contention was specifically refuted by pointing out that there was proper publication of the notices under Section 4 of the Act. The other objection raised was that the whole acquisition was done with malafide intentions. The acquisition of the land for planned development was not covered under public purpose. Stop.